We have breaking updates on the ongoing battle over Missouri's Second Amendment Preservation Act, SAPA, and the case has once again reached the Supreme Court. Recently, the Trump administration filed its response in this case, continuing to argue that Missouri's state law is invalid and that the court should deny review. At the same time, they've indicated that if the matter returns to the lower courts, parts of the case will be dropped. What makes this situation even more complex is the recent political shakeup in Missouri's leadership, which could directly impact how this challenge moves forward. Missouri's Attorney General, Andrew Bailey, who has been leading the charge in defending SAPA, has just been selected by the Trump administration to join the FBI as co-director. Bailey announced that he will officially resign as Attorney General on September 8th, just before this case heads to conference at the Supreme Court on September 29th. His resignation leaves uncertainty over who will continue Missouri's legal fight in defense of SAPA and whether this transition could stall or reshape the challenge altogether. For context, this lawsuit centers around Missouri's 2021 Second Amendment Preservation Act, commonly called the SAPA law. This law was designed to assert the state's interpretation of the Second Amendment by restricting state and local officials from assisting federal agencies in enforcing gun laws or regulations that Missouri believes violate the Second Amendment. Under SAPA, Missouri law enforcement officers, agents, and state officials are prohibited from cooperating with federal authorities in enforcing federal gun laws that the state views as unconstitutional. On top of that, the law created a civil remedy allowing private citizens to sue Missouri officials if those officials helped enforce federal laws that the state considers to be violations of the Second Amendment. In essence, SAPA shifts enforcement power away from state officers and places it directly in the hands of Missouri residents. However, the law immediately came under heavy fire from the Biden administration. On initial review, the district court struck down Missouri's SAPA law in its entirety, siding with the federal government. Missouri appealed that ruling to the Eighth Circuit, seeking a temporary stay to keep SAPA in place while the appeal moved forward. That request was denied, which then led Missouri to file for emergency intervention from the Supreme Court. The Supreme Court considered Missouri's emergency application earlier this year, but in an 8-1 decision, the court denied the request. The only justice who supported Missouri's position at that stage was Justice Clarence Thomas, who voted in favor of granting the stay. The denial meant the SAPA law remained struck down while the case continued its way through the courts. From there, the case went back down to the lower courts for further review, ultimately bringing us to where we are today with the Trump DOJ continuing its opposition to SAPA and new developments shaking up the state's legal defense team. On review, the Eighth Circuit ultimately sided with the federal government and the Biden administration, striking down Missouri's Second Amendment Preservation Act once again in its entirety. In response, Missouri filed a petition for certiorari with the Supreme Court, asking the court to take up the case. One of Missouri's key arguments is that the Eighth Circuit contradicted established precedent. Missouri points out that the appellate court admitted the structure and potential operation of SAPA were valid, yet still struck it down because it disagreed with the purpose of the law, namely, to protect the Second Amendment. In other words, the court rejected the law not because of how it functioned, but because of its underlying intent. Missouri further argues that the Eighth Circuit mischaracterized how SAPA operates. The court concluded that state officials could be sued under the act because it viewed compliance with SAPA, essentially refusing to enforce certain federal gun laws, as a form of enforcement. Missouri counters that this interpretation is fundamentally flawed. Simply choosing not to enforce federal laws that the state believes violate the Second Amendment should not be equated with actual enforcement actions. Originally, SAPA faced opposition from the Biden administration. But now, under the Trump DOJ, the federal government has taken control of the case. After several months of delay, the Trump administration recently submitted its official response to the Supreme Court. In that filing, the administration maintained that SAPA is invalid and insisted that the lower court reached the correct decision. However, their response also included an important twist. The Trump DOJ stated that if the Supreme Court denies review and sends the case back to the district court, they would voluntarily narrow the scope of the judgment previously obtained under the Biden administration. They explained that upon re-examining the case, the United States now has concerns that the lower court's ruling went too far. Specifically, they believe the judgment improperly extends to areas where SAPA simply prevents state officials from enforcing federal laws, conduct that may be protected under the anti-commandeering doctrine. The Trump DOJ noted that the uncertainty surrounding how certain provisions of SAPA will be applied makes the lower court's sweeping judgment even more problematic. Because of that, they announced that once the case returns to the district court, they would file under Rule 60B of the Federal Rules of Civil Procedure to narrow the scope of that judgment. So, after months of silence, the Trump DOJ finally responded by doubling down on its argument that SAPA is unconstitutional, urging the Supreme Court to deny review. At the same time, they signaled a willingness to concede that parts of the lower court's judgment were overly broad and should be rolled back. In response, Missouri argued to the Supreme Court that even if the current administration follows through and drops part of the lower court's judgment, the core ruling from the Eighth Circuit would still remain intact. That means the flawed analysis from the appellate court would continue to stand as precedent, potentially harming Missouri and other states in future Second Amendment cases. For that reason, Missouri urged the Supreme Court not to sidestep the case, but instead to grant review, reverse the Eighth Circuit, and correct the errors in its decision. As of now, this case is scheduled for Supreme Court conference on September 29th. Typically, when the justices hold a conference, we see their decision reflected in the order list the following Monday. However, given the developments surrounding this case, there's a real possibility that the conference date could be moved, or that the court could choose to delay its decision. It's also possible the court simply sides with the Trump DOJ's position and sends the case back down to the lower courts without review. Adding to the uncertainty is the fact that Missouri Attorney General Andrew Bailey has resigned. He recently accepted a position as a co-deputy director with the FBI. Bailey's departure is a major shift, especially considering how instrumental he has been in advancing not only Second Amendment challenges, but also other significant lawsuits Missouri has brought against federal agencies, foreign actors, and even major corporations. His absence could weaken Missouri's presence in this case. We're already starting to see the ripple effects. There have been filings at the Supreme Court regarding changes in Missouri's legal counsel, along with some procedural missteps that may have been tied to staff turnover within the Attorney General's office. While those issues appear to have been corrected, they highlight how the shakeup in Missouri's leadership is complicating this challenge and could slow the case down even further. For now, the case is still scheduled for conference on September 29th. But whether it stays on track or faces delays remains to be seen. What is clear is that this case could have enormous implications, not just for Missouri's Second Amendment Preservation Act, but for similar laws in other states seeking to protect their citizens' Second Amendment rights from federal overreach. I'll be following this case closely and keeping you updated as soon as more information comes out. If you found this breakdown helpful and want to stay on top of these critical updates, the best way to support the channel is by subscribing so you don't miss future videos. And as always, thank you so much for your continued support.